Start. Heard the learned advocates for the parties stop. Rule by consent. The rule is made returnable forthwith. Stop passes. The short point for consideration which arises in the matter is as to whether the tribunal could have directed to payment of substance allowance during the pendency and till the disposal of the application stop. In that regard, undisputably, the division bench in an unreported decision in the matter of Air India Limited versus MR and another start appeal stamp number 351 of 2003 along with the other appeals and writ petitions clause delivered on 30 June 2003 has clearly held that stop passes. Broadly, the cases in the tribunal could be categorized in three categories. Stop. As far as the first category of cases is concerned, they are cases in which a workman is dismissed for misconduct after due inquiry and on scrutiny by the labor court or the tribunal, as the case may be. Also, the inquiry is found to be valid. Stop. In such cases, there would be no justification for providing payment of subsistence allowance to the workman concerned. Stop. The mandate of the statute is to complete the proceedings with a period of 3 months. Stop. If in every case application for interim order is filed and on that application considerable amount of time is spent, both the High Court. Stop. The legislative mandate or early hearing of the application would be completely defeated. Stop. In such cases, the tribunal would be justified in taking up the main application for approval for hearing. Stop. But there are cases in which either the domestic inquiry held by the management is set aside on the ground that it was defective or there was only a facade of an inquiry or there was no inquiry at all. Stop. But for the procedure involved by the decision of the court in the interest of speedy finalization of the cases in which the workmen were dismissed from service by requiring the labor court or the tribunal itself to hold a de novo inquiry, the position would have been the moment it is established that the domestic inquiry is invalid or there was no domestic inquiry at all, the penalty imposed would have had to be set aside but without prejudice to the right of the management to hold a de novo inquiry. Stop. In that situation, during the period of de novo inquiry, the management may be asked to give subsistence allowance to the workmen considered with the standing orders or the rules regulating the conditions of service. Stop. It is because of the procedure, namely the holding of domestic inquiry by the labor court / tribunal itself, evolved by the decision of the court, it has resulted in this situation which, even as the order of dismissal remains undisturbed, a de novo inquiry is held to find out as to whether dismissal was justified or not. Stop. We are of the opinion that if de novo inquiry is ordered to justify the order of dismissal and the matter has been unduly protected for no fault of the workman, stop, the tribunal would be justified in awarding subsistence allowance to the workman in appropriate cases stop. We, however, hasten to add that the grant of interim relief is not a matter of course and the exercise of such power should be used sparingly and only deserving cases stop passage. The law on this point being well settled, it is clear that unless the tribunal comes to a finding that the domestic inquiry was either a total force or that it was not just and fair or it was contrary to the provisions of law, the question of directing the empower stop over.